Hello friends, welcome to Institute of Banking Excellence. Today we are going to talk about checks. Before starting the video, if you like it, please press the like button, share and subscribe it with your friends. Without wasting much time, let's get started. Characteristics of check and crossing. Checks are either encashable at the counter or payable through account. The directions to make payment through the account are given by drawing two parallel lines on the face of the check. The drawing of these lines is called crossing. The payment of a crossed check cannot be made in cash. Crossing and sections of Negotiable Instrument Act. 1. General crossing, Section 123, two parallel transverse lines, either with or without the words "not negotiable." Anything written without two transverse line does not mean that check is crossed. 2. Special crossing, Section 124, if name of bank is written on the face of the check or on backside of it, this makes the check specially crossed. It will be paid through the same banker whose name is written across the check, or if nominated, through his representative bank. The drawing of transverse parallel lines is not necessary for special crossing. 3. Section 125 state about the person who can make the crossing. 1. The holder of a check can make the crossing. 2. The banker on whom the check is crossed specifically can cross that specially again to another banker. 4. Section 126 lays down that a. Where a check is crossed generally, the banker on whom it is drawn shall not pay it otherwise than through the account. b. Where a check is crossed specially, the banker on whom it is drawn shall not pay it otherwise than the banker to whom it is crossed or his agent for collection. Liability of a paying banker. The paying banker incurs liability under Section 129 if payment of a crossed check is not made through account. The banker becomes responsible to drawer, maker of the check, and not to payee or holder of the check. Not negotiable instrument, Section 130, not negotiable words on the face of check do not make it non-transferable, however it bears great practical significance as it takes away one major characteristic of the negotiability of the instrument. The holder for value of the instrument gets better and absolute title of the property of the negotiable instrument. The inclusion of the words "not negotiable" takes away this characteristic of the check, and holder for value does not get a title better than the transferor. Account payee, the same is not covered under NI Act, however, RBI has made observations on the AC payee checks as, account payee checks for any person other than the payee constituent shall not be collected. Double crossing, a check crossed specially cannot be crossed further. However, a bank can appoint another bank as its agent for the collection of check which is crossed specially. But it must contain the words "as agent" or "on behalf of so and so bank." Protection to banker. Paying banker gets protection under following sections. 1. Against forged endorsement on order checks, Section 85(1). 2. Against forged endorsement on bearer checks, Section 85(2). 3. Against forged endorsement on demand drafts, Section 85(a). 4. Against material alteration on a check, Section 89. 5. Payment of crossed check, Section 128. However, to seek protection the banker must have made payment in due course and in accordance with Section 10 of NI Act. Section 89. In case a check which is originally crossed, but has been materially so altered that crossing has been obliterated with such adroitness that it seems as an uncrossed check, and paying banker makes payment over the counter, gets protection under the Act under Section 89 of the Act, which provides that if such a check where material alteration has been made with such skill that it seems as uncrossed check, the banker liable to pay the same is absolved of liability if the payment thereof is made as per apparent tenor of the check and otherwise in due course. Thus, for seeking protection the following is essential. 1. The check does not seem to crossed at the time of payment. 2. The payment is made in accordance with provisions of Section 10, that is in due course and with apparent tenor of the check. Payment of check. The banker is liable under the Act to honor the checks of its customer if the sufficient balance is available. But the check must be paid as per instructions of the maker and in accordance with apparent tenor of the instrument. Failure will make the banker liable to action under Section 31 of the NE Act 1882. Stale check, a check issued with date prior to its issuance that is issued on April 25, 2018 bearing date April 20, 2018 is called stale check. Post-dated check, issued with date subsequent to the date of issue like issued on April 25, 2018 bearing date May 20, 2018. Such checks become valid on the date of instrument. Hindi date. Any check bearing date with accordance to Hindu calendar remains valid and should be paid after matching the Sakha calendar with international calendar. Amount in check. In case there is difference between the both, the banker should pay the amount written in words as per Section 18 of the Act and not dishonor the check. As per CTS 2010 RBI guidelines, amount written in words is called legal amount whereas amount written in figures is called courtesy amount. Material alteration. Any alteration in the check which changes the original directions of payment is called material alteration like 1. Change in date. 2. Place of payment. 3. Amount of payment. 4. Name of payee, endorsee etc. 5. Placing word bearer. 6. Uncrossing of check. Any material alteration renders the instrument invalid and void, as such changes shall be confirmed by the maker of the check under his full signatures. Forged signatures. If the signature on the check is forged, it is not to be paid at all, and if paid, banker incurs liability on himself, since check does not contain mandate by the customer. The bank does not get any protection for carelessness of the customer like not keeping the checkbook under lock and key etc. Payment of mutilated check. The banker before making payment of such checks must satisfy himself whether check is torn with intention of cancelling it. Endorsement is regular. The bank is not required to verify the endorsement, however he must ensure that endorsement is regular, like the two endorsements are not in same handwriting, same ink etc. Refusing to pay a check. Banker may refuse to honor a check, otherwise in order and having sufficient balance available for appropriation, if 1. The drawer countermands the payment. 2. Death of the drawer. 3. Insolvency of the drawer, in case insolvency proceedings are started against the customer. 4. Insanity of the customer. 5. Assignment of credit balances to another person. As per Transfer of Property Act, a person can transfer his assets to another person. In case of transfer of credit balances into another person's account, the checks can be refused. 6. On receipt of Garnishee Order. The obligation of the banker to honor his customer's check is extinguished on receipt of Garnishee Order from the court. Garnishee Order. In case a debtor fails to pay his debt, the creditor can approach the court for issue of Garnishee Order on the banker of the debtor. The orders issued by court prohibit the creditor, customer of the bank, from recovering the debts and the debtor, bank is a debtor for normal depositor, from making payment. The account of a customer who is a creditor to the bank is suspended and banker who is debtor is prohibited from making the payment. The creditor at whose request the orders are issued is called judgment creditor, the debtor whose money is seized is called judgment debtor, and banker who is debtor of the customer is called the garnishee. The Garnishee Order, Section 60 of Code of Civil Procedure, is issued in two parts, that is Order Nisi and Order Absolute. Vide Order Nisi. The court asks the banker to stop payment from the account of the judgment debtor and also seeks explanation from the banker that why the amount lying in the account of judgment debtor should not be attached. The banker upon receipt of this notice should immediately inform his customer so that further issuance of checks and dishonoring of the same may be avoided. The court next issues Order Absolute, whereby entire balance in the account or a specified amount is attached. The amount attached is called garnished amount. In case amount specified is mentioned in the Garnishee Order, it will be applicable to that amount of funds and banker can allow drawal of checks beyond that amount. However, the banker usually debits the garnished amount and put it in their sundry, suspense account. The following are not attached via a Garnishee Order. 1. Where bank has right to set off his debt, that is, bank can use the funds to set off his debt and the Garnishee Order will be applicable to remaining amount. 2. The Garnishee Order cannot attach the amounts which are received after the service of order on banker. 3. If an account is opened in joint names and one of the account holders is judgment debtor, the joint account cannot be attached. 4. In case of debt taken by the partnership firm, the individual accounts of the partners can be attached, but for individual debt the partnership account cannot be attached. 5. The Garnishee Order does not apply the amount of checks, draft, pay orders, sent for collection or items lying in custody, as for all such instruments the bank is acting as agent. Attachment Order by Income Tax Authorities. The attachment order of income tax authorities can attach 1. All the sums lying in the account of the assessee, including debts due but not payable and any amount received subsequently. Under Section 226(3) of Income Tax Act 1956. 2. The amount lying in joint account, partnership account for individual assesses can be attached. The share in such joint accounts shall be assumed equal until something to the contrary exists. This is it for this video. Thank you so much for your love and support. Stay tuned for the next one. Till then, bye and stay blessed.